Welcome back to another edition of Between Two Fars. I'm Warnicki Miller, speaking with Judge Reid Prouty, Vice Chairman of the Armed Services Board of Contract Appeals. Today we're going to talk about efficiency in litigation. You may find that you're in a hearing and you've got a limited amount of time to present the government side of the case. This isn't an unusual situation. We usually go in knowing that the hearing is going to be a 2-day hearing or a 5-day hearing, and that may seem like a lot of time when you get started, but as you get rolling and you're dealing with pre-hearing matters and disposition of procedural motions and things of that nature, you may suddenly find you don't have as much time to present your case as you initially thought. So we want to explore ways that you can be most efficient with the time you have and present your case in the best possible manner. So to get started, let's just talk about witnesses. Can you talk to me a little bit about what you've observed with witness testimony, what you find to be efficient and what you find maybe is overkill or unnecessary?
Sure. As you all know, it is de novo review of the COFD. Which means that it doesn't really matter to the judge too much what the contracting officer was thinking when she or he wrote the COFD, unless those facts are independently helpful to us. And also, it doesn't really matter what the CO interprets the contract to be, for the most part, because that's a legal determination. That's for me to do. The worst thing in the world, and it happens very often, is to put the contracting officer on the stand and have him or her read large portions of the contract into the record, and then read large portions of the COFD into the record, because that doesn't help. First, I can read, and there's no reason for somebody else to read the contract or the contract documents to me unless there's a very specific point being made. Certainly, the contracting officer can help contextualize things, and there's no reason for them not to do that. And that can be a helpful and effective use of your time when they're testifying. But for things that are relatively straightforward, the contract had the different citations clause, and I'm going to read it to you. That's in the FAR. Please don't do that. It might seem to make sense to you, but that's a fact already in the record. The contract officer's basis for his or her contracting officer's final decision generally not so important. Now, there are exceptions. For example, if it's a termination for default or a termination for convenience, and there's an allegation of bad faith, where that actually does make a difference in whether or not it was a valid T for C or T for D. Well, then having the contracting officer explain why she or he did what they did, that is important to prove good faith. But if the good faith of the CO is not an issue in the case, it's just whether or not, the specifications said what the CO thought they said, or whether or not there was a differing site condition, or who was responsible for delay. Those are things where the contracting officer's individual view of things might not be as important as you might think. Remember, you don't have to defend the COFD, you have to defend the ultimate result of the COFD, and that's a very important distinction. And so if you're spending your time talking about the COFD, or spending a lot of your time talking about it, you might find a way to better use your time.
That's excellent. Do you have any other generalized concepts or ideas? If the clock's running down, you're getting to your last couple of hours of presenting your case, what sort of things do you want to see?
It's funny because there's a question at one point, is it better to have an affidavit than a live testimony, right? Because that certainly, it doesn't cost you a dime or a second of your allotted time. And generally, I like live witnesses better because there's invariably going to be things that I'm going to want to ask questions about. And I'm one of those judges that asks a lot of questions of witnesses. So if you're ever before me and I'm asking your witness a lot of questions, please don't take that as an indication that you did a bad job preparing that witness or the witness did a bad job giving their testimony. It just means that sometimes it's more efficient for me to ask questions, or there are things that I'm getting ahead of that would be helpful to me. When you write a decision, sometimes when you're at a hearing, everybody has these unstated assumptions about the way things happened at a site. Everybody sort of understands what the dispute is about, but nobody's ever really crystallized it. And it's sort of gone on, and everybody gets the facts, but there's nobody's ever put it all together in one little bullet. And then when you have to write the decision several months later, it's like, okay, well, this is a case about this, but nobody ever said that. So it might be helpful for me to get the witness to say, let me make sure I understand the way these bolts were put together, and sort of go through them. The witness says, yes, that's right. In that case, I've got a neat little nugget that I can put into my decision, and sort of make sure that we're all on the same page. So there's going to be that going on, which is a reason why it is helpful to have witnesses that can be questioned as opposed to an affidavit. Obviously, if your time is limited, you have to make strategic decisions, and you make the decisions you think are the best serve your client, and best get out what you want to get out. But the most important thing are sort of straight up facts that are important, or material to the dispute, as opposed to sort of normative things like, well, I was trying to do a good job, or this was a really sloppy contractor, if that's what the person wants to say. When that's not really important, what's important is what the contract said, or how they executed, what went wrong. Those kind of facts are the ones that are most important. I'll add that, obviously if it's your last day of trial and you've got an hour left, it's late to do this. However, the best thing you can do to make sure you have a smooth time where you don't run out of time is to spend time preparing witnesses. Sometimes witnesses, and this happens a lot with engineers, want to explain a lot. They feel it's their chance to unburden themselves and to answer questions that aren't given.
They're being helpful.
They're being helpful.
Yes.
And there's nothing wrong with being helpful, except when it eats into your time. So, you might want to prepare your witnesses to basically just go into the subjects that you think are important for your case. If I think there's a subject that's important that hasn't been asked, I'll probably ask about it. Okay? That doesn't mean don't count on me to do your case for you, but prepare your witness, spend time going through their testimony so that there's not extraneous things. And you'll find that the time preparing, as you all know, so there's a lot more time spent preparing than actually in the courtroom. And the more time you spend preparing, actually, usually the shorter the testimony is, because it's more clear and concise and gets more to the point.
Excellent. Thank you so much for this insight. It's been incredibly helpful, and I think we might be able to snag you for another episode or two as we wrap up this wonderful series of the inside look at the ASBCA with Judge Prouty. Join us again next time, Between Two FARs.